You have the right to remain silent. Anything you say and can will be used against you in the court of law. You have the right to talk to a lawyer and have them present with you while you're being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questionings if you wish. All right. You good, dude?
You good, dudes? Everybody good? You good, dude? That's right, Jenny. Sleep is overrated. I recognize that picture. Nonchalant enchilada. Hi. You guys are so great for coming in and hanging out with me. You're in. Paula, hello. Jenny. Cindy, how are you? How are you today? Jackie. Jackie. I've missed you. Orange Rose. I love seeing that orange rose in chat. I love seeing it. Rubber Ramada, you are not sleeping, my friend. You did a good long live today. I am good. I am good. Natasha, look at that picture. What a cutie. He's so cute. 2:30 in the morning, and you are an insomniac, aren't you? I appreciate that in all the ways that are the most important. Spinster, hi friend. Oh, you're hiding behind your little logo, but that's cool. You look like you're standing in the lava. Hi. Let me go down here. No sleep for you. No rest for the wicked. Thank you, Rubber Ramada. If you would hit that thumbs up for your girl on your way in. Hi. Who was that? Where is that? Wait, who was that? Oh, it's Southern Cats. I couldn't catch you. What is that? What is that? That's a little bitty kitty with a kitty behind it. I'm obsessed with y'all's avatars. I really am. Sherry, you know why you finally caught a live? If you look on my page, I end up doing a lot of like little short videos and stuff. And I don't go live a whole bunch. I want to. I want to go live a bunch. You're watching it 2 times me to catch up. Well, the first 4 minutes was just kind of chilling out music. Hi, Sherry and Ali. Ali X. Okay, so I don't have a whole bunch of stuff going on. I just kind of want to hang out with you guys and chill because I never get to do that. And everybody was streaming Lori Daybell's trial all week, and nobody wanted to talk about the little boring jury instruction. So I just kind of want to sit and listen to them and see what happened today. And did you survive that trial? Yeah, in 1.5 speed today. It was a bunch. It was a bunch. You're not new. You're already a seasoned veteran. We already know. I like hanging with y'all too. I like hanging with you too. Doesn't do me any good if I don't have anybody here hanging out. Oh, I do have something. I do have something for y'all. Here, let's do this. Let's do this. I'm going to gift my first 5 memberships for April. Yay! Let's see if it went to anybody that we know. Scratch that paint. Tina Perkins, Joyous, Miss Me, and David Price. Sherry, I was so confused. I was so confused. I hurt my own feelings. And then let's go ahead and do our second round and see if we come up with anybody that we know. Oh, there's plenty of names we know. Joy, Indy, Isham, Stephanie, you're green now. Evie and Heathen 74. Welcome to the Guardians of Firelight, which means I get to play my song twice, because that's why we do this. Oh, you're so sweet. Thank you for the super sticker. Look at that fox dancing. You can't see it up on screen, but you can definitely see. Yeah, welcome, everybody. Oh, I gotta do it one more time. Okay, one more time. All right, welcome all new Guardians. I'm so glad to have you here with me. And Heathen, yeah, family dinner and sending our army boy back tomorrow. Lots of toast. Thank him from the bottom of my heart for his service. My husband is a Marine. I know that's not easy for a family, so we appreciate you. You guys want to watch this with me? Just kind of hang out, watch this with me? Let's do that. I love that super sticker. That fox is really cute. Thank you so much for that. All right, so put subtitles on just in case she says something out of pocket. Yes, Rubber, thank you. Hugs. Hugs for your army boy and lots of toasts. Lots of toast. All right, let's see where we're at. I started 9 minutes in because they were just sitting down and doing all the stuff. So that's where we're at. It's an hour, and I'm sure there'll be stuff in between that won't be that trying. That's true. Oh. Oh, Sherry, I love that. Thank you. Yes. Yes. We were talking about Detective High and Tight earlier in another chat, and how the cameraman must be over in the Jose Morales trial. They must have gotten the same camera guy. Look at her hair, don't. Look at her hair, don't. Oh, Natasha, thank you for the super sticker. Don't forget to thumbs up, please. And your little cute heart hands. Thank you so much, Natasha. Thank you. Got your crackers out.
All right. We're on the record in CR 2021-001704, State of Arizona versus Lori Daybell. The state is present, the defense is present, the jury is not present. This is the time set to discuss the final jury instructions. Let me confirm with the defendant that, is it still your intention to not put on any evidence?
Right now, Your Honor, yes. As of this morning, I mean.
Well, do you anticipate that changing?
No.
All right.
Then why answer the question like that, little lady? Why answer the question like that? No, not right now. Well, do you see that changing? No, I don't. Bitch, just answer it. Just say you've given up and you're going on with life in prison forever.
Because that does affect how these instructions will be read to the jury. So for now, we're assuming you're not putting on any evidence. Let's just go through page by page. I think it's probably the easiest way to do it. On the cover page, I did correct, I had 2001 instead of 2021, and I corrected the case number. The first instruction at the top, page 2, duty of jury evidence to be considered and rulings of the court. These are standard instructions in Arizona. I'm assuming there's no objection to those from the state.
Who does, Ollie? Who does? Spill the beans. Who comes across as condescending? Me or the judge? Or she does. She does come across a little condescending. She irks everybody. Oh, Lori does. Okay. She does come across as condescending and a little bit delusional a lot. Sorry, Natasha, I meant I hit it when you reminded me. Oh, girl, she's on the sauce today. Lori does. She is, and it's the same judge and prosecutor, and she's representing herself. Is it going to be televised?
No objection.
From the defense?
On page 2?
Yes.
No objection.
All right. Then on page 3, I did remove the stipulations because I don't think there were any stipulations. So on page 3, direct and circumstantial evidence, production of witnesses and evidence, redacted exhibits, those are standard. Any objection to those from the state?
Your Honor, I did object to the production of witness and evidence.
I want to hear about that because that's a standard given when we have a situation where we've heard about people like JJ, Tylee, Alex Cox. We've heard about Summer. We've heard about Detective Moffat. None of those people were called at trial. So I think.
So they were talking about production of witness and evidence. In a legal context, it looks like that it says that it refers to the process of bringing forward people or witnesses and evidence to support a case in court, and it involves using subpoenas and stuff to compel an appearance by witnesses or documents that they normally wouldn't have. So she didn't put on any, I don't know why they're objecting to that, but
I think this instruction simply says that neither side is required to call, basically everyone that's mentioned in the evidence.
Yes, as long as the defendant is okay with it. Obviously, I've not seen that previously included in an instruction. My concern was the burden shifting potentially, saying that neither side is required, and that seems to imply or in opposition of the fact that the defendant need not present anyone anyways, ever. That's my concern with that instruction.
All right, before we talk about that one, let me hear from the defendant. Any objection to the direct and circumstantial evidence and then the redacted exhibits on that page?
No, those are fine. Your
Okay,
Honor.
what are your thoughts on the production of witnesses and evidence?
I tend to agree with the prosecutor, but
That it shouldn't be in there?
correct.
Well, if the parties are stipulating that it's not in there, I'll remove it.
tell me you don't know or what the judge is talking about without telling me, Lori.
Is that the case?
I believe so, Your Honor.
Yes, Your Honor.
All right, by the stipulation of the parties, I'll remove that instruction.
She looks back at the
I
table.
probably
She's like,
should have
what does
brought
that
my hard
mean?
copy because you guys are working off a hard copy on my computer. This is kind of maybe paginate different. So now my next ones are indictment is not evidence, self-represented defendant. Any objection to those from the state,
No, Your Honor.
from the defense?
No.
All right, then the comments are not evidence. The reason I highlighted that is it was to alert everyone that I did change the language in that a little bit because the defendant's self-represented. It mirrors what I did in the opening, what I read to the jury before opening statements, more or less, in changing it from the attorneys to the prosecutor and the defendant talk to you about the law and the evidence. Are there any objections to that instruction from the state,
Not as changed, no, Your Honor.
from the defendant?
No, it's good.
All right, then we have credibility of witnesses, and on my page 4 is testimony of law enforcement officers, but that might be on your page 5. Any objection to those two from the state
No, Your Honor.
defense?
No objection to the ones that are in there.
All right, then we have expert witness. Any objection to that from the state,
No, Your Honor.
from the defense?
Nope.
All right, based on the defendant's indication that she's not going to be presenting evidence, I would remove defendant's testimony, I would keep in defendant need not testify, and I would remove defendant witness prior conviction if that remains the case. So any objection to that from the state,
No, Your Honor.
from the defendant?
Nope, no objection.
All right.
I find it very refreshing today that the judge doesn't have the microphone so close to him that you can hear his wheezing through the nose. He does have a very nasally nose thing that goes on when his microphone is too close. I'm just saying that out loud.
Can we add in there something?
What's
Is this a
that?
time to ask to add something in there?
Go ahead.
The standard 19, the defendant statement voluntary.
Voluntariness of defendant's statements.
Mhm.
That probably should be in there. What's the state's position?
No objection.
I will add that. I'll add that right after defendant need not testify. Just making a note. All right, then we have.
I do
jury
not.
Jury not to consider penalty. Any objection to that from the state
No.
defense?
Nope.
All right, the state emailed this morning. I don't think the state, I think the state wants the alternative presumption of innocence, burden of proof in the Rajis. Is that correct?
Correct, Your Honor.
You want to make a record on that?
Your Honor, the current version the court has in here discusses the various levels of the burden of proof for preponderance and clear and convincing, which are not relevant to this. Case law is very clear under Portillo that the court is only required to present the Portillo instruction, which is partially on the next page in my hard copy, which explains to the jury the burden of proof for a criminal case. I think that going through other levels of burdens of proof without understanding or being provided context for that is confusing to the jury, is not necessary, and Portillo does not require it. So,
Okay, so the Portillo instruction is from People versus Portillo out of California. And it was basically designed to caution all the juries about like unreliable witness, like an eyewitness that has been identified. Okay, let me see if I can explain this without mucking it up. An eyewitness has identified the defendant, and the case hinges on that identification. So they have a concern about like memory distortion. Back in the day, we had like suggestive lineup procedures where you'd go and you'd see them on the wall and you'd be like, pick out which one it is. And, you know, honestly, a person who's gone through a lot of trauma may not remember that right away. So it's basically the Portillo instruction is about the potential of the jury not being able to pick out unreliable witnesses. It's not the exact wording, but basically it's like eyewitness identification is not always reliable. People make mistakes when identifying somebody, especially when they're under stress, and even if they've only had a brief encounter. Does that make sense? Is it me or does Lori answering the judge with no? Yeah, to me it does. To me it seems disrespectful. That's my opinion, but yeah. Yeah, it's great seeing you here, Jenny. Tony says, it's great to see you, Natasha. She's dumb enough she says she's not going to at the close of trial on Thursday. She said that she didn't plan to testify and that she rested. So at this point, she's rested right now. But she does have until the jury hears her say that the defense has rested. So she very much could change her mind. Oh, yeah, I'm jealous of the prosecutor's hair. Are you not? I'm kidding, Sherry.
requesting the court just provide what has been mandated, which is the Portillo instruction.
What's the defendant's position?
We agree. It's confusing.
Okay. So
Sorry to keep interrupting, but it doesn't make any sense. So the purpose of it is to protect the defendant from misidentification. It's known to cause wrongful convictions. It encourages a juror to critically evaluate the conditions under which the identification occurred. All of the witness that says, "Oh, that was Lori that was there. That was Lori that was there." Um, they're just trying. This instruction is to reinforce confidence and accuracy in the identification of the defendant, who happens to be in this case also the pro se, lawyer in her own case. So for her to go, yeah, we agree, it's confusing. It's confusing because you don't understand what the Portillo instruction is. That's why it's confusing.
I think that's just the last two paragraphs, right?
Yeah, from the three standards through the preponderance and the clear and convincing. So it would still have, the presumption of innocence, and then it would go to the beyond a reasonable doubts portion.
Okay, I will, by stipulation of the parties, change that instruction. So it'll read, the law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. Then I delete until the last two paragraphs. So then it will read, the state has the burden of proving the defendant guilty beyond a reasonable doubt. The rest of that paragraph. And then the next paragraph, proof beyond a reasonable doubt is proof that leaves you firmly convinced. And that entire paragraph, is that the agreement?
Yes, Your Honor.
Yes.
Okay. So my pages are not going to be the same as yours at this point. So we'll just go through it a couple at a time. Evidence of any kind, voluntary act, and then absence of other participant. Any objection to those three from the state?
Yes, Your Honor. And the evidence of any kind, I had sent in my email that we should remove acting with the advice of an attorney.
The judge needs to talk about her enchiladas to get her fired up a bit. Hi, Carol Lou. How are you? Is it Carol Lou? Carol Lou? When I watched this earlier today, that Lori was mimicking the prosecutor because she has no idea what's going on. Amen. Say it louder. Yeah, I agree. I think that's a dangerous part of representing yourself, right? Is that you just, if you don't know all the legal jargon, and you can tell that this prosecutor's, ran cases like maybe not as high profile before. I'm not sure. I haven't looked into the prosecutor herself, but you run that danger of, you have access to a law library, but you don't know what the prosecutor's going to say. And so you're not sure if you're going to be able to understand it right then and there. Like if it were me sitting in the courtroom and they're throwing all of these things at me, hopefully I would have had a copy of and they do have a copy of what the jury instructions were going to be. And that way I could look up some things like, okay, this sounds fair. What does this mean? What does that mean? I would have done my homework if it were me and I were able to. Do you think the jurors actually know she's in prison already for unaliving her children? The lack of questions about the kids make me think that they might. So I know that if it didn't have anything to do with this trial particularly and the conspiracy charge that she was involved in, they were throwing things out left and right. They were like, you're not supposed to hear that. I object. So the chances are that they may know. I think when they went through the picking things out of the jury, there are lots of people we can truly say don't watch the news and may not know who Lori Daybell was before this trial. So they tried to pick the most unbiased jurors they could. So there's a chance that they don't know. From what I've seen and read, Lori manipulated everyone and got through her life by her looks, not the brightest bulb. Yeah. I mean, I don't know. I think it takes a lot of intelligence to get through life based on a physical appearance, because I think that seems to be a lot of work. It's just my opinion. I don't have to get up. Me personally, I don't get up every day and put on a full face of makeup and do my hair every day to come on YouTube. Now, will I eventually? Maybe. That's a lot of work to see somebody like superficially, do that every single day. Michelle, it is so nice to see you. It is so nice to see you. I know. Isn't that a great name? She's hiding in plain sight. Thank you. Michelle says, please hit that like button. If you would, I would be in your debt. Okay, let's go on and see what else she doesn't know what she's talking about.
Defendant is her own attorney, so she is, I think it should just be a period after evidence is left to the defendant, period.
You're right. I will remove that sentence. So what I would propose is it would read as follows. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce any evidence is not evidence of guilt. Is that what the state requests?
I would have left the decision on whether to produce any evidence is left to the defendant, period. And then the next sentence, cutting out acting with the advice of an attorney, and then have the last complete sentence as well.
I don't have a problem with that. What's the defendant's position?
I agree.
You agree with the state's
Yeah, I
wording?
agree with, yes, just to cut that part of the sentence off.
Okay. I already deleted it, so read it back to me, state, please.
Sure. So the state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce any evidence is left to the defendant, period. Then the defendant's decision not to produce any evidence is not evidence of guilt.
So the decision on whether to produce any evidence is left to the defendant. Okay, when we're done, we're going to print out another copy and make sure everyone's on the same page. All right, let me turn to the defendant. We've addressed evidence of any kind. Any objection to voluntary act and absence of other participant?
No objection.
All right, then we have motive. Any objection to that from the state?
We did have flight or concealment in the ones that we
I'm
have.
sorry, you're right. I should have stated, I did delete flight or concealment. I don't think it's applicable in this particular set of circumstances. So then we just have.
And I think that we understand flight and concealment would probably not be applicable because of her current hotel stay. I'm not sure she would be a flight risk.
Have motive.
No objection to motive, Your Honor.
And from the defendant?
Yeah, no objection to motive. No objection.
All right, here's where mine's going to change a little bit. I did the charged offense, each instance where it says first degree murder, where it used the numerical first, I changed to a capital spelled out the word first in that, and then in the definition of first degree premeditated murder. And the reason I highlighted in here, there's a couple highlights, a person and under premeditation, she or a co-conspirator. Those are changes I made to the standard because the standard just says defendant. So let's just talk about the charged offense, the definition of conspiracy, the definition of first degree premeditated murder, and then the definition of premeditation. Any objection to those with the changes that I've stated from the state?
No, Your Honor.
From the defendant?
No, no objection to that.
All right, then where it's altered a little bit, so there was an accomplice based on liability, based on the result of the crime that I had here. I've deleted that and instead put accomplice, the traditional definition of accomplice, in the definitions section. And I think what I'm gonna have to do is we're gonna print out a fresh copy and give it to you guys when we get there. And what I've inserted here is elements of a conspiracy, scope of proof of conspiracy, proof of membership in conspiracy, which in my original draft only had the scope, I think, of proof of conspiracy in a different spot.
Correct.
But does the defendant, I'll give you a few more minutes.
What did I hit?
On the subject, are you requesting any other justification instructions?
Yes. Lori Vallow was transferred from Idaho to Arizona for the trial. She was extradited from Pocatello in Idaho to Maricopa County in Phoenix so she could face these charges. And then following this trial, she's scheduled for the other one in June. And that's the conspiracy of the homicide of Brandon Boudreaux, her niece's ex-husband. You're welcome. Oh, you guys are amazing. I appreciate you, all of you. Did I skip too far? Oh my gosh, I don't. That's fine. We're fine.
Well, I was going to ask for that for 2.04A.
For what?
The 2.04A, 2.0401A.
What's that? I don't have them all memorized.
Oh, the Arizona 13204.
Is that a Raji you're referencing or a?
Yes.
Hold on, let me bring them up.
I don't have them all memorized.
It's the Cashion. Is that what that is?
So, when somebody in court refers to Raji instructions, it's a set of jury instructions that they usually, well, a lot of times they use them in California employment law cases. So that's interesting. But it stands for recommended Arizona jury instructions, in case anybody didn't know. But people in California use them as the Rudder Group Raji instructions. So I thought that was interesting to note. Rudder Group's employment law jury instructions. And then in Arizona, in this particular one, it's recommended Arizona jury instructions. So just the basic instructions.
I was on the wrong one. So we are going to be asking for those, but
I don't think I'm clear on what you're asking for.
so we were going to ask for the 4.06, the defense of third person, the 4.07, defense of premises, the 4.11, crime prevention.
What was the crime that was being prevented?
The assault on myself, on my daughter, on my brother.
Defense of third person, defense of premises, and defense of or crime prevention.
Correct.
It's just generality. I don't know what she's going on about. Maricopa County is where David Edison is in prison. Oh my goodness, you lost your nephew in 2010. If you ever want to talk about it, I would be glad to talk about it with you, Sydney. Anytime that you would ever want to talk about it. Nonchalant enchilada is sorry for your loss. I didn't think she knows what she's talking about either. But like I said, then again, neither do I, right? I'm certainly not a lawyer, but I'm certainly apparently a little bit more versed than Mophead over there. She doesn't know what she's going on about. Yeah, I'm so sorry to hear that, Cindy. It's never easy to lose a family member. I'm glad whoever it was is in prison, though.
Correct.
In addition to
Hi, Carolina.
justification, deadly physical force.
Correct.
All right. Those get really convoluted and long, and there's a lot of repetitive information in those, but the case law says if there's even the slightest bit of evidence, then it's error for me to not give those. So what's the state's position?
Your Honor, I think understanding the case law, the defense of third party would be appropriate. The defense of premises.
I don't have it in front of me, but I think the defense of premises requires that the person be forcing in or trespassing.
Correct,
on
rather
the property.
than being invited into the home. So I don't see that justification in defense of premises is appropriate, given the facts that we have here.
Let me look at it, because doesn't it also say or remain unlawfully if they were asked to leave?
I guess we have no, let's see.
In Arizona legislature, the use of force in defense of premises says a person or their agent in lawful possession or control of the premises is justified in threatening or using physical force against another when and to the extent that a reasonable person would believe to be in immediate to believe it immediately necessary to prevent or terminate the commission or attempted commission of a criminal trespass by the other person in or upon the premises. So knowing that, exactly. So knowing that deadly physical force is justified only in defense of yourself or third persons as they're about to is described in a whole different area. And even attempting to, hi Ava, even attempting to say, yes, Charles was in a hotel in another part and he just came to pick JJ up to take him to school, even to make the assumption that he was trespassing there and using use of force in defense of premises in jury instruction or trying to get that, no, ma'am. Exactly. Charles was paying the damn rent. He was no intruder. He was no intruder. He was not trespassing and using it the third party the third party removing of somebody from your premises by deadly physical force was not justified by the bat, etc. But she is delusional.
There's no evidence of that specifically, but I guess it could be inferred, and I would hate to risk a reversal on something like that. So let me take a closer look at it.
The fact that she's debating standardized language in jury instruction tells me all I need to know about her. It tells me all I need to know. You're debating standardized stuff just to, this is your last ditch effort to piss off the judge. Lori, don't flatter yourself. Charles had moved on to somewhat, a million times better. Absolutely. In State versus Ewer, the Arizona Supreme Court emphasized that justification defense applies specifically to the defendant's conduct and not to that of the victim. So the court is she is talking to hear herself talk because she doesn't understand what she's saying. Most of us have to sit here, even paralegals and regular prosecuting and defense attorneys have to look this stuff up regularly. It's not, it's not just something that even the judges, don't have those memorized. So she's definitely not going to know what she's talking about. I would hate to be in prison or jail with her as well. Yes, Jenny. Thank you, everybody, for coming in and hanging out with me.
I think the other question is on that goes to then the lawful possession or control of the premises, given that Charles Vallow himself was paying for the premises.
Amen.
Which we have admitted evidence of.
You do have evidence of it. The key considerations that the jurors have to make when evaluating a defense of premises claim. As jurors, this is what you would have to consider as a juror. Lawful possession. Was the defendant lawfully in possession or control of those premises? Was there a perceived threat? Did Lori reasonably believe that force was immediately necessary to prevent or terminate a criminal trespass by Charles? And was the force that was used proportionate to the threat? That's the three things. These are standard jury instructions. Like, get over it, girl. It's going to be in there.
The evidence also admitted is that he flew into town and came over to that house, not living there at the time. So it does infer it as well.
Well, he's on the lease.
Hello.
That would seem to have some apparent authority to be there, but let me take a look at
Nitwit.
it.
The storm. gotta sing it? It's the cutest thing ever. You put some loin fire in, you take some Nephi out. You put a zombie in, then you try to cast it out. You do the loony Lori and you twist things all around. Greed's what it's all about. I love that. You absolutely rock. You win the internet today. I appreciate you. Sarah Boone and herself could share a cell to provide entertainment for the other inmates. Lori would eat her for lunch. She would eat her for lunch. Thank you all. I'm going to watch cute videos of puppies and animals to get my heart ready for tomorrow. Heel, Rubber, Chat, and Mods, we love you too. Go do your thing, Sherry. Go do your thing. Like I said, tell your boy thank you for his service, and we'll be thinking about him. Storm, that was amazing. Ew! Don't ever say that again. You hand in your devices and go to your room. It was good. That was pretty good. Oh my gosh, I did it again.
Of proof of conspiracy, proof. The charged offense, each instance where it says first degree murder, where it used the numerical first, I changed to
On whether to produce any evidence is left to the defendant, period. And then the defendant's decision not to produce any evidence.
from the defendant.
Yeah, no objection to motive.
I know.
All right,
Jeez.
here's where mine's going to change a little bit. I did the charged offense, each instance where it says first degree murder, where it used the numerical first, I changed to a capital spelled out the word first in that, and then in the definition of first degree premeditated murder. And the reason I highlighted in here, there's a couple highlights, a person and under premeditation, she or a co-conspirator. Those are changes I made to the standard because the standard just says defendant. So let's just talk about the charged offense, the definition of conspiracy, I'm sorry, the definition of first degree premeditated murder, and then the definition of premeditation. Any objection to those with the changes that I've stated from the state,
No, Your Honor.
from the defendant?
No, no objection to that.
All right, then where it's altered a little bit,
Sorry, I'm whispering really loud.
so there was an accomplice based on liability, I'm sorry, based on the result of the crime that I had here. I've deleted that and instead put accomplice, the traditional definition of accomplice, in the definitions section. And I think what I'm gonna have to do is we're gonna print out a fresh copy and give it to you guys when we get there. And what I've inserted here is elements of a conspiracy, scope of proof of conspiracy, proof of membership in conspiracy, which in my original draft only had the scope, I think, of proof of conspiracy in a different spot.
Correct.
But does the defendant need those printed out to review? Because I've changed, I have
I was
changed
going to
it.
ask for those to be added, so I did
Okay.
review them with my advisory council.
All right, I want to make sure though that you are literally on the same page with what's going to be read.
Yeah,
So,
I would like them to be printed so I can see them.
all right. We'll come back to that when we get you a hard copy. What I wanted to ask
Okay,
the
Ava.
parties was I initially included the Raji 4.04 for self-defense justification. But in a second look this morning, I think 4.05, which is justification, self-defense, physical force, and it specifically talks more about threatening or using deadly physical force, I think is more applicable. So what's the state's position on that, inserting 4.05 in place of 4.04?
I would agree, Your Honor. This relies mostly on physical force. Obviously, we're discussing deadly physical force here. So otherwise, the jury has to try to implant deadly physical force throughout this entire instruction.
And I think they should both be in, but
Well, while we're on the subject, are you requesting any other justification instructions?
Well, I was going to ask for that for 2.04A,
For what?
the 2.04A, 2.0401A.
What's that? I don't have them all memorized.
Oh, the Arizona 13204.
Is that a Raji you're referencing or a,
Yes.
hold on, let me bring them up. What's it called?
It's the Cashion. Is that what that is?
So
25.39 in case I hit it again, because we're back where we were. So she's referencing the effect of ignorance or mistake upon criminal liability. Okay. This particular statute addresses the impact of ignorance or mistake against the criminal liability. While there isn't a subsection, 13.204 is made of two parts. I don't know what she's talking about subsection. So ignorance or mistaken belief regarding a matter of fact does not absolve a person from criminal liability, right? Being ignorant of the law, she said something. I'm sorry, it made me laugh. Being ignorant of the law does not absolve you from being culpable, right? It negates the required culpable mental state for the offense. It supports the justification defense because you were ignorant or you made a mistake concerning a matter of law. It doesn't relieve a person of criminal responsibility.
I was on the wrong one. So we are going to be asking for those, but
I don't think I'm clear on what you're asking for.
so we were going to ask for the 4.06, the defense of third person, the 4.07, defense of premises, the 4.11, crime prevention.
What was the crime that was being prevented?
The assault on myself, on my daughter, on my brother.
Defense of third person, defense of premises, and defense of, or crime prevention.
Correct.
In addition to,
Dang it, Storm. There we go.
all right, I want to make sure though that you are literally on the same page.
Well,
with
welcome
what's gonna
in,
be read.
Storm.
Yeah,
So-
I would like them to be printed so I can see them.
All right,
I'm not going to say
Um,
that out loud, but
we'll come back to that when we get you a hard copy. What I wanted to ask the parties was I initially included the Raji 4.04 for self-defense justification. But in a second look this morning, I think 4.05, which is justification, self-defense, physical force, and it specifically talks more about threatening or using deadly physical force, I think is more applicable. So what's the state's position on that, inserting 4.05 in place of 4.04?
I would agree, Your Honor. This relies mostly on physical force. Obviously, we're discussing deadly physical force here. So otherwise, the jury has to try to implant deadly physical force throughout this entire instruction.
And I think they should both be in, but
Well, while we're on the subject, are you requesting any other justification instructions?
well, I was going to ask for that for 2.04A,
For what?
the 2.04A, 2.0401A.
What's that? I don't have them all memorized.
Oh, the Arizona 13204.
Is that a Raji you're referencing or a,
Yes.
hold on, let me bring them up. What's it called?
It's the Cashion. Is that what that is?
So
I was on the wrong one.
Yeah, she sure didn't want that
We
one
are
in.
going to be asking for those, but
I don't think I'm clear on what you're asking for.
so we were going to ask for the 4.06, the defense of third person, the 4.07, defense of premises, the 4.11, crime prevention.
What was the crime that was being prevented?
The assault on myself, on my daughter, on my brother.
Defense of third person, defense of premises, and defense of, or crime prevention,
Correct.
in addition to justification, deadly physical force.
Correct.
All right, those get really convoluted and long, and there's a lot of repetitive information in those, but the case law says if there's even the slightest bit of evidence, then it's error for me to not give those. So what's the state's position?
Your Honor, I think understanding the case law, the defense of third party would be appropriate. The defense of premises,
I don't have it in front of me, but I think the defense of premises requires that the person be forcing in or trespassing
correct,
on the
rather than
property.
being invited into the home. So I don't see that justification in defense of premises is appropriate. Given
I don't see the
facts that we
justification
have
of
here.
I don't see the justification of defense of a third person is going to be appropriate either, but they're going to allow it.
Let me look at it, because doesn't it also say or remain unlawfully if they were asked to leave?
I guess we have no, let's see.
There's no evidence of that specifically, but I guess it could be inferred, and that I would hate to risk a reversal on something like that. So let me take a closer look at it.
I think the other question is on that goes to then the lawful possession or control of the premises, given that Charles Vallow himself was paying for the premises, which we have admitted evidence of.
The evidence also admitted is that he flew into town and came over to that house, not living there at the time. So it does infer it as well.
Well, he's on the lease. That would seem to have some apparent authority to be there, but let me take a look at it.
It doesn't. I mean, what did she say? Doesn't even matter. The state's the one that has to prove it anyway. So.
It refers to criminal trespass, which I think the point here is you cannot be criminally trespassed off of your own property.
Did she just giggle? She did, didn't she? She was like, it was almost maniacal. It's exactly right, Jackie. It's exactly right. And it was planned.
So I will give the 406, which is justification for defense of a third person.
Welcome back, Ava. That's right, enchilada. She sure does. Were you there? Yep, I agree. I'm serious, even the defense of a third person, I'm like, whatever, even simplified to the
I'm not going to give justification in defense of premises that requires that there be a criminal trespass. I
Thank
think it's confusing to the jury also. If there's an argument that's made that he committed a criminal trespass because he was on the lease, he had authority to be there, and he was, even if he didn't have authority to be there, he was invited in to get his son.
He sure was.
In lieu of that, Your Honor, then we would ask to add 418, 4.19, defensive residential structure.
We're at 31.14 because I always do that. Okay, so 41 or 4.18 justification, use of physical force in crime prevention is what she just introduced. A person is justified in using or threatening physical force against another if, under the circumstances, as a reasonable person, you would believe them to be you would believe it to be immediately necessary to prevent the other's commission of a crime. The force used must be proportionate to the threat. The person must have a reasonable belief that the force is necessary to prevent the crime. The defense does not justify the use of deadly force. If I remember correctly, I do believe that he is dead. And then 4.19, that's use of deadly force in crime prevention, applicable to aggravated assault, homicide, manslaughter, SA, kidnapping, armed robbery, burglary in the first degree. The person has to have a reasonable belief that deadly force was necessary to prevent the commission of those particular serious crimes. Hi, Swan. So in both instructions, if evidence of justification is presented, the state bears the burden of proving beyond a reasonable doubt that the defendant's actions were not justified. Swan says, hi, Rubber. So that's the premise, that's the basis of what she just introduced.
Record on 4.11, which is use of force in crime prevention.
Sorry, I was looking at 418 that defense just raised. Let me go back to 411.
I say, man, we are all over the board, aren't we? In none of these. Past your bedtime. Ali, good night. Thank you for coming and hanging out for a little bit. I appreciate you so much. Ava says, hi, Swan. Welcome in. Get some sleep, Ali. In none of these that she's talking about was the force proportionate to the threat. It just wasn't. She must have had to have a reasonable belief that the force was necessary to prevent any type
Trying
of
to find
crime.
411, but my
So,
search is not.
I'm going to hop back to 418. 418 is not applicable. 418 applies to home invasion type situations, and it talks about threatening or using deadly physical force. If the person against whom the physical force is threatened or used is in the process of unlawfully or forcefully entering or having unlawfully or forcefully entered a residential structure or occupied vehicle.
Right. He
So
wasn't
there's no indication that
intruding.
Charles forcefully entered the house. So I'm not inclined to give 418. Does the defense want to be heard further on that?
No, because she doesn't know what it's for. And I don't think 419 should be in there either.
No, Your Honor.
And then was there another, you said after 418?
I just said 418 and 419. I guess that's the presumption of that.
Or, so 419. That's applied to the residential structure, so that one wouldn't be applicable if 418 is not applicable.
That's right, Swan.
Okay.
So I'm not going to give 419. Did the state look at 411 yet?
Just found it, sorry.
Enlighten me of what you're talking about, Carol Lou. Life imprisonment. If she's found guilty of the conspiracy, is there a certain name that it comes along with? Is that what you're saying? Is that what you're asking? Dead hoe, but other than that, I don't know. When she tried to say Charles hit Alex with a baseball bat as an ex-baseball player, if he had hit Alex with said bat, Alex would be without a head, in my opinion. Yeah. Yep. She's currently serving multiple life sentences without parole in Idaho. Yeah. But the additional conspiracy charge, the additional conspiracy to commit homicide, is there a term? The prison term is life imprisonment. Probably no. I mean, she's already serving life, so just depends on the severity of the crime. Conspiracy to commit first degree is treated with the same seriousness as the actual commission of the first of the crime. You could tell I was reading too much into it. I was like, what do you mean term? What do you mean? Like, what do we call her besides dead bitch? Okay. The length of time. Yeah, it's based on the severity of the crime, but its first degree is treated with the same as the actual commission of the crime. Carolina. That was funny. Mandatory life sentence. Silly. Just in case there is life after death, they're making sure she stays. I'm sorry, Carolina. It's mandatory life, Rubber. Oh, Storm, yes. I would live a long, happy life if I saw her do that. A long, happy life. She can hope in one hand and, she can hope. Even if they did grant her an appeal, the other cases and all the other life sentences and everything else that she's gone through, plus a subsequent trial right after this one, there's no way. There's no way. She's not going anywhere. Right now, she's just spinning her wheels to hear herself talk. There's no redemption. Yeah, there's not. She's screwed. Just get up and stand up and break those chains and walk out.
Your Honor, I think probably given Carson and the allegations that the victim used a bat, we would have to give that as well as then the instruction for the crime that they are indicating they believe Charles was committing, as is required per the.
So you agree that 411 needs to be given? So that's my reading as well. So I will give 411, just so we're clear, I'm removing 404 self-defense justification. I'm adding in 405 self-defense justification, deadly physical force. I'm going to add in 406 defense of a third person. I'm going to add in 411 crime prevention. Okay, I think that brings us to the definitions. I removed deadly weapon. I think I had it in there initially because I thought it was in the justification statute, but closer read, it's not. So in the definitions that I have right now, I have intentionally with the intent to, and then intent may be inferred.
Are you?
Then I have knowingly, willfully, knew.
Are you, Storm? Did you leave the Mormon faith for a particular reason? You don't have to talk about it. I mean, just a question. You've been calling her Lori Horse since the Melanie Gibb phone call. Lori screwed up your YouTube algorithm. They think that you're Mormon now. You don't know much about this case until recently, so you've been watching videos from 5 years ago. Oof. Yeah, there's a lot to catch up on there. Mostly just a lot of circle talk, but it's just a holiday break for her where she can be the center of attention. She'll be unbearable when she gets back to her cell. I agree.
And if the state is required to prove the defendant acted knowingly, that requirement is satisfied if the state proved the defendant acted intentionally. Then the next paragraph, a defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense, and the rest of that paragraph. Any objection to those from the state,
No, Your Honor.
from the defense?
No, Your Honor.
And then here is where I've inserted the traditional definition of accomplice because I deleted the completed act definition of accomplice. So this says accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following: 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Any objection to that from the state,
No, Your Honor.
from the defense?
No, Your Honor.
Then I have a few more definitions: act, conduct, physical force, and a definition of deadly physical force. Any objection to those from the state?
You said something else I don't see in here, so sorry.
Act.
Act was a previous page, sorry.
I kind of did it in alphabetical order. So accomplice went in, then act. So act, conduct, physical force, deadly physical force.
No objection.
From the defense?
No objection.
While we're in the definition section, I'm going to have to look at when we're adding crime prevention and defense of a third party, whether there's any additional language in there that would require additional definitions. But other than that, are there any other definitions the state's requesting that I didn't include?
Other than, obviously, the state hasn't looked at either of those, either new instructions requested by the defense to see if there's additional information. So I would have to look at that prior to approving these.
Brandon was the niece's, her niece's ex-husband. Waiting for Emma to show up and claim she sent. Oh. Well, that's interesting. Yeah, I hope the jury isn't confused either. But, you know, most of them, to be honest with you, are standard. When they start reading them to the jury, they try to, I don't want to say dummy it down, because dummy it down is not a proper term. That's kind of insulting or condescending, isn't it? They kind of put it in terms, for the most part, that they understand. I would hope. So last witness to state, yeah, no, I didn't, and I didn't watch. I watched highlights of most of the trial, But I had already listened to her first trial, and nothing that she says surprises me at this point. Yeah, they'll streamline it a little bit. A little bit. Streamlining, I guess you could say it that way. Yeah, not dummy it down, but to put it in terms that I as a person could understand, instead of all the legal jargon.
Okay. But other than that, you don't have any that come to mind.
Not off the top of my head, Your Honor.
All right. How about from the defendant?
No, Your Honor.
So then the rest of this is pretty standard. It's the jury foreperson and the closing instruction. And then I have a form of verdict. Any corrections, objections to any of those from the state?
Just the form of verdict, changing the 1 ST as well to first degree.
Okay. There's no.
I respect that.
We don't need any interrogatory on dangerous. It's automatic, right?
It would not be automatic.
It's
I don't
not.
believe so, because it does not require the use of a weapon. So we would actually need to have a penalty phase to
Okay,
have that
so
determination.
That would be done in the second phase, if there's a second phase.
Correct.
Okay. Let me turn to the defense. First of all, any other definitions that you think need to be included that I didn't include?
Hold on one second.
And you put your finger up at the judge. She better be glad he is so passive. That judge and that prosecutor, they have dinner regularly. You could just tell. Detective High and Tight was sitting next to her after his testimony yesterday. I know they probably work out together. They go to the same gym. I'm being facetious. I don't know that. I'm just talking out of the side of my head.
Your Honor, we had missed one that we wanted added, was mistake of fact 205. I'm sorry, I don't want to backtrack.
Oops.
That was a big old sigh. Poor guy. $42.45. Okay, let's see. Religious trauma many years ago, old and boring now. Like I said, I respect that. I think that's amazing. Came out the other side of it, traumatized, but still able to be old and boring. So that's a win-win for me. Time, so that the defense can understand it. How many pills do you think he takes? Oh, before this trial? Probably as much as he can stand. No, I doubt it. I think that was so cool, Storm. You were doing you. To heck with the, yeah. Gotta do what you gotta do for you, right? Eventually it's gonna be legal everywhere and we'll stop putting people in jail for it. I live in Texas and it's not legal here. Can't just sit in the parking lot and do it. You'll get arrested. It's ridiculous. Okay, a mistake of fact. She's putting, she wants to add in ARS 13-204, understanding mistake of fact. That occurs when a person has an incorrect belief about a factual situation, which may negate the necessary mental state required to commit a crime. So it negates the culpable mental state required for the commission of the offense, or it supports a justification defense. Really? So the application of this into a criminal case like hers is going to be, the mistake of fact would be, the mistake must be reasonable under the circumstances. So you made a mistake and now he's dead. Okay, cool. The mistake must directly relate to a material fact of the case, and the offense must require a culpable mental state, intent, knowledge, recklessness, or criminal negligence. The defense is not applicable to strict liability offenses where intent is not a required element. Oh, give me a break. A valid mistake would be like taking someone else's umbrella from a stand and believing that it's yours. And then if you're charged with theft, the mistake negates the intent to steal. Miss me with your bullshit. Selling alcohol to a minor is another really good one. Believing that they're legal age, but you don't verify their ID. Oops, I made a mistake. Now this kid drove, down the highway going 85 and smashed into another car. I love your commentary. If you saw Chad Daybell of Iowa's trial, you know that Emma claims she did the computer searches. Yeah, I know what she said. Emma was brainwashed her entire life. It's hard breaking that. Yep, I agree with that.
The revised jury instructions from 2 years ago don't have a 205.
Sorry, it's 204. I apologize.
She said
Causation,
204,
ignorance
Judge.
of fact, is that what you're talking about?
Correct.
2.0401A, ignorance or a mistaken belief as to a matter of fact does not relieve a person of criminal liability unless, one, the ignorance or a mistaken belief as to a matter of fact negates the culpable mental state required for a commission of the offense, or two, the ignorance or a mistaken belief as to the matter of fact establishes a defense of justification. So what's the mistake of fact that you think exists?
Hi, Heather. Yeah, Storm, you're cool. I think you're cool. Heather, it's so nice to see you. You ask for this to be put into the jury instructions, yet you don't know why you wanted it there. You don't know why there would be a reasonable mistake or a valid mistake of fact.
Your Honor,
And
it's mostly the mistaken of fact that have been presented as evidence in this case, like one shot versus two shot. You were being attacked, you weren't being attacked. It's things that the state is proposing that I'm denying.
Well, you can deny those and you can argue that, but that's not really what is meant by a mistake of fact.
that's right.
It refers to a misunderstanding of the facts that would somehow negate any criminal liability.
The ignorance or mistake regarding a matter of
In other
law
words, you
doesn't.
have to be under a false belief about a fact. I think an example might be if someone's breaking into your home or someone's coming into your home, you thought it was a burglar and you shoot them and it turns out to be your spouse. That might be a mistake of fact.
That ain't what happened to Charles.
So a dispute as to what the facts are, what the facts mean, wouldn't warrant this instruction unless you have something else.
That was all. That was what I was thinking.
Okay. What I think I'm going to do is I have to go back to my office in the central courthouse. I have to edit this a little bit. I'll add in those instructions. If you guys can wait here, we'll get you a clean copy by noon. Review that copy over the weekend, make sure there's no other additions, corrections, or mistakes. And then the procedure will be on Monday when the jury comes in. I'm going to ask if the defendant's ready to proceed, and I'm assuming you're going to say that the defense rests. And when that happens, we'll hand out the final instructions, and I'll read the final instructions, and we'll go right into the closing arguments.
Your Honor, then I'd asked defense previously, there are officers who are under subpoena still, that they be released at this point?
That's fine, Your Honor.
All right. And well, anyone at this point can be released from your subpoenas. Is that correct?
That's correct.
Okay.
Yes.
I'm just trying to decide the best start time. I'm thinking read the instructions at about 11, break for lunch, and go into the openings early at 1, or you can start and have it broken up by lunch.
I would prefer the court's option of reading the instructions, going for an early lunch, and then not having my
All right.
closing.
I'll have my staff contact the jury and tell them to report at 11. And then we'll still meet here at 10:30, make sure everything is good on the instructions and the defendant's intentions to rest. And then I'll read the instructions before lunch. That may mean we break a few minutes early for lunch, but we'll have them come back at 1 and go into the closing arguments.
So that's pretty much where they're set on the jury's instructions. So that's where they're going to stop on that. It looks like this next part right here looks like they're going to talk about the trial set for the homicide of Brandon Boudreaux. So that's where they're going to talk about that a little bit, and then we'll go for the night. I just kind of wanted to see it. Some people think that jury instruction is boring. I just find that you kind of go through it and you kind of get a feel for how the prosecution and the defense thinks that they did, depending on what kind of things that they'll throw out there, or how, you've already got their whole book written. They've already written everything in their journal, and now it's just kind of like the end scribbles of, so how do you think you did? You know what I mean? I can't stay here forever. People would get so bored. It's 12:17 p.m. here on Good Friday. 2986. Wow. You were Ned Schneider last week? Yeah, you changed names like Sarah Boone collects paper clips and staples and cheese in her drawers. And by drawers, I mean physical drawers, not drawers that she puts on. Is it really, Cindy? Oh, I don't have a birthday song, but I need to get one,
All right,
don't
while
I?
we're here, I'm going to call the other case as well, CR 2022-001242, and the state is here, the defendant's here. I'm going to go ahead and set the official trial date to begin May 30th at 9:30 a.m. Actually, 10 a.m., May 30th at 10 a.m.
Your Honor, are we still meeting though the 29th to do strikes?
Yes, I'm going to get to that. I will set a final trial management conference to discuss the remote questionnaire and confirm we're all good to go for the second trial.
Jenny. Yeah, no, not the knickers. Oh,
For May 14 at 10 a.m.
And Your Honor, I will say okay for now. Obviously, we don't have the victim here and we didn't notify him of this hearing. So if that does not work for him, then I will ask to move that.
All right, for now, we're setting the final trial management conference, May 14 at 10 a.m. At that time, we'll discuss modifications, if any, to the previous questionnaire. We'll discuss the exact timing of that questionnaire going out, but it'll go out probably May 21st and end sometime on May 26th or 27th, because the 26th is a holiday. And then we will meet on May 29th to go over those responses that the remote questionnaire produces. I'm going to set that for 1 p.m. on May 29th.
Your Honor, I received a notice from the state this morning, actually, about notice of 404B information for that trial. So are we going to set a 404B hearing for that as well? Would that be at the same time, or do you want to do that at a different time?
Let's discuss that on the 14th.
Okay.
I did see that come in as well a couple of days ago.
I'm going to turn that down and leave it playing in the background. So you've never heard it, Legal Vice? Like a suitcase of love. She's going to spend the weekend, but she hasn't decided, even though she has. I reckon she'll spend the weekend. Yeah, I think she has. I think she really, honestly, yesterday in trial, I think I saw her give up on this one. Just a little extra time away from home. So on October the 2nd of 2019, Brandon Boudreaux was shot in Gilbert, Arizona, and the bullet apparently narrowly missed him. And they linked the vehicle that was used in the shooting, which was a Jeep that was registered to Charles, to Alex, to Lori's brother. And he's believed to have been the person that shot him and was also involved in the shooting of Charles Vallow, obviously, a few months earlier than that. And he died in December of 2019 of natural causes, and he was never charged, obviously. And prosecutors are alleging that Lori conspired with Alex to kill Boudreaux, and he was motivated apparently by financial gain. We know how she feels about these insurance policies, or to remove perceived spiritual threats. There's text messages that they're going to present in court that reveal that Lori and her niece, Melanie, which is Boudreaux's ex-wife, discussed strategies to monitor Boudreaux's movements, referring to him as a zombie, and a term that they used for all the individuals that they believed that were possessed by evil spirits. Obviously, most of you guys know that. So, yeah, I agree. Mormons wear garments under their regular clothes. I wonder if Lori still wears hers. I think they make them, don't they? Don't they make them? I don't know. I could be wrong. The charges for this next trial, conspiracy to commit first-degree murder. The schedule we just saw is going to be May 30th. Lori has pled not guilty. She's representing herself, as she is doing in this current trial. And if convicted, she faces life in prison with the eligibility of parole after 25 years. The upcoming trial is a broader series of legal proceedings against Lori Vallow, or Daybell, however you want to call her. She's already been convicted in Idaho for the murders of her 2 children and the conspiracy to murder her then husband's previous wife, Tammy. And then, of course, she's going to be found guilty in this one, right? And then she'll be found guilty in that one, and then they will just bury her under the prison. Yeah. Ew. No, I'm not highlighting that. That's gross. That's terrible. Okay, let's see if there's anything important they're sitting here talking about while we went over that.
May 11 on that trial, so as defendant want to make a record because I am going to exclude time.
Yeah, I think they're just pretty much talking about the same thing. Cindy says, hi, Rubber. They're pretty much talking about the same thing that we've already talked about. So I think we'll probably end it out here. And I just want to say thank you. I have the best guardians in the entire universe and the best mechanics that work on all the cars here in the chat. No! Heather, you're suspended. Back to the toilet portal, Lori. Gross. Oh. Yeah, you have to, right? You have to buy the garments. I thought so. Oh, you have to buy them. So they're not just like, hey, you have to wear these. I think somebody was telling me that if you don't purchase actual garments, you end up getting the ones like they give you at the hospital after childbirth that are just kind of like mesh panties or something of that nature. They're like throwawayables. Isn't that gross? Do they even protect anything? I mean, the whole idea of wearing panties is for some type of protection. Right? Yeah, I can't believe we're talking about that. Okay, we're done. I'm not going to say this anymore. We're not going to do that. Good night, friends. And as always, seriously, thank you for hanging out with me. I am always intrigued by everyone in this chat. Y'all make me happy. I'll see you guys really, really soon.